I'm going to talk about some of the core principles of the Declaration, and I'm going to particularly focus on why the Declaration and the principles that it reaffirms are particularly important to identifying and challenging men's violence against women and girls. The Declaration, the purpose of it was to reaffirm women's sex-based rights, which are set out in the United Nations Convention on the Elimination of All Forms of Discrimination Against Women, the 1979 CEDAW, which were then further developed in the UN Declaration on the Elimination of Violence Against Women in 1993, and which are contained in other human rights instruments. Women's rights as set out in those international human rights documents are based on women's common experiences as a sex. And they were not based on individuals' subjective sense of gender identity, which is something that Laura's already talked about and the way in which that's defined. For example, Article 1 of the CEDAW defines discrimination against women to mean any distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms in the political, economic, social, cultural, civil, or any other field. And the UN Women's Gender Equality Glossary defines sex as the physical and biological characteristics that distinguish males from females. It's very clear that the definition of sex is a biological one. And it was a biological definition of sex which the writers of CEDAW and the Declaration on the Elimination of Violence Against Women had in mind when those documents were written. The Women's Gender Equality Glossary of the UN defines gender, on the other hand, as the roles, behaviours, activities and attributes that a given society at a given time considers appropriate for men and women. These attributes, opportunities and relationships are socially constructed and are learned through socialisation processes. They're context, time specific and changeable. Gender determines what is expected, allowed and valued in a woman or a man in a given context. In most societies, there are differences and inequalities between women and men in responsibilities assigned, activities undertaken, access to and control over resources, as well as decision-making opportunities. But this definition recognises that gender is a socially constructed hierarchy. It isn't a neutral hierarchy. It isn't a neutral construction, it's a hierarchical one. And it helps to maintain and reinforce women's social and economic inequalities with men. The CEDAW recognises that the socially constructed roles and norms which constitute gender are part of the wider fabric of structural inequality between men and women and seeks to challenge them. Article 5 of the CEDAW states that states should take all appropriate measures to modify the social and cultural patterns of conduct of men and women with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or the superiority of either of the sexes, or on stereotyped roles for men and women. Women's rights, which have been achieved on the basis of sex, are now being undermined by attempts to incorporate the concept of gender identity into international human rights documents and international law in many countries. One of the ways in which the concept of gender identity is being promoted internationally is through the use of the Yogyakarta principles, which Laura has already mentioned. These principles make recommendations about the application of human rights standards to issues of sexual orientation and gender identity, or they say they do. In fact, they focus very largely on gender identity. They have no formal status as a human rights instrument, but they're widely promoted as representing international best practice in relation to people who define themselves as transgender. Laura's already discussed the Yogyakarta Principles definition of gender identity. I just want to reiterate that that concept, with its emphasis on individual feelings and individual modes of dress, divorces gender, which is a socially constructed hierarchy, from the material circumstances which gave rise to it in the first place. It turns gender into an individual subjective identity based on an idea. And it reinforces what Article 5 of the CEDAW has called the social and cultural patterns of conduct of men and women, which the CEDAW wants to change, was designed to modify or eliminate. Principle 31A of the Yogyakarta Principles Plus 10, which were published in 2017, calls on states to end the registration of the sex and gender of the person in identity documents such as birth certificates, identification cards, passports and driver licenses, and as part of their legal personality. In other words, the ultimate aim of the Yogyakarta Principles is the complete elimination of all sex and gender markers from the law. Once sex has been eliminated from the law, there would be no need for gender markers, because the law will treat everybody as a separate individual with a separate an identity totally based on subjective feelings and divorced from material reality. The principles go on to say that while sex or gender continue to be registered in law, states should enable individuals to change their legal sex or gender without any eligibility criteria or any prerequisites. And that it specifically states there should be no prerequisite based on age. So tiny children, according to these principles, should be allowed to change their gender identity, or perhaps more realistically, have adults change it for them. This denial of the material realities of biological sex advocated in the Yogyakarta Principles denies the material realities of women's sex-based oppression throughout the world, which includes female infanticide, female genital mutilation, forced marriage, men's widespread control over women's reproductive capacities, the exploitation of our reproductive capacities in surrogacy, the sexual exploitation of women and girls in prostitution and pornography, and levels of physical violence against women, which the World Health Organization has described as a global health problem of epidemic proportions, because it is so commonplace and widespread. Denying the material reality of sex-based oppression by replacing the category of sex with the concept of gender identity in law and policy erodes women's sex-based rights. And the Declaration states that this amounts to a form of discrimination against women. Retaining the primacy of biological sex as a social and legal category and preventing its replacement with gender identity is crucially important to our ability to identify and name the widespread violence against women and girls, which is perpetrated by men, and to develop strategies for challenging that violence. The UN Declaration on the Elimination of Violence Against Women says that violence against women is one of the crucial mechanisms by which women are forced into a subordinate position compared with men. In other words, violence against women and girls is a tool of male dominance and control. The Declaration on Women's Sex-Based Rights includes 9 articles, as Laura's already said. Article 8 deals specifically with violence against women and girls. But there are other articles of the Declaration which also affirm important principles which are crucial to our ability to challenge this violence. And I'm going to talk about those as well as talk about Article 8. Article 1 of the Declaration reaffirms that the rights of women are based on the category of sex. The core of the Declaration is the principle that in all law, in policies and in practice, the category of woman should mean adult human female, the category of lesbian should mean an adult human female whose sexual orientation is towards other adult human females, and the category of mother should mean a female parent. If women cannot name ourselves as a biological sex, we cannot accurately name the violence that is perpetrated against us. If men are included in the category of women, this makes it more difficult for us to challenge sex-based violence either individually or collectively. Basing our social and legal definitions of womanhood on sex, a biological reality, rather than on gender identity, a social construction, is crucial to our ability to hold on to the rights that we have and to fight for an end to violence against women and girls and to fight for true sexual equality. We can't establish sexual equality if the law doesn't recognise the existence of sex. Article 8 of the Declaration, as I said, reaffirms the need for the elimination of violence against women, and one crucial aspect of that is the maintenance of single-sex spaces and services. The Declaration affirms that single-sex spaces for girls and women, including lesbian-only spaces, should be based on sex and not on gender identity. Our right to define our own physical boundaries and protect ourselves from men's violence is threatened by demands that we include men who claim a female gender identity in women's refuges, rape support services, public changing rooms, public toilets, and other spaces. The presence of men who claim a female gender identity in single-sex spaces and services, whether as service users or service providers, undermines those services' role in promoting the physical safety, privacy and dignity of women and girls. It also makes women and girls vulnerable to violent men who gain access to single-sex services by claiming to be women. There are many examples, but one example I would give is that of Christopher Hambrook in Canada, who in 2014 claimed to be a woman, used the name of Jessica and gained access to women's refuges, or shelters as they're called in Canada, in Toronto. He had already convictions for rape and for sexual assault on a child when he went to the shelters. While in the shelters, he sexually assaulted 2 women. He's since been convicted for those sexual assaults. But that would never have happened if the refuge hadn't accepted, or perhaps had to accept, his definition of himself as having the gender identity of a woman. The Declaration says that single-sex spaces and services should be allocated on the basis of sex and not gender identity, and that should include all specialist services for girls and women subjected to violence, such as rape support services, shelters, specialist health services, and all of the other services in which single-sex provisions promote the physical safety, privacy, and the dignity of women and girls, including hospital wards, other health services, and prisons. Female prisoners have no choice about who they share cells or showers with. The prison authorities decide that for them. They're one of the most marginalised groups of women in every country. In 2018, the prison service in England placed Karen White, a man who claims a female gender identity, in a women's prison while he was waiting trial on charges of rape and other sexual offences. White already had convictions for sexual offences against children when he was placed in that prison. And while in the prison, he sexually assaulted 2 women prisoners. We can only stop abuses of this kind if we reaffirm that the category of women is based on sex and not gender identity, in law and in practice. Another aspect of Article 8 is the principle that the collection of data relating to the monitoring of sex inequality should be based on sex and not gender identity. Article 4 of the UN Declaration on the Elimination of Violence Against Women requires states to collect data relating to the prevalence of different forms of violence against women and on the effectiveness of measures aimed at preventing and redressing this violence. Identifying violent males on the basis of their claim to a female gender identity has now become common practice in the criminal justice systems in many countries. Recording men's sexual and violent offences as having been committed by women makes accurate collection of data about violence against women and girls impossible. And so it hinders the development of policies aimed at combating violence against women and girls. If you can't identify it, you can't develop policies to challenge it. The Declaration therefore says that states should be required to record the identities of perpetrators of violence against women and girls on the basis of their sex, and that should include all information collected by public bodies, including the police, prosecutors, and the courts. Article 4 of the Declaration reaffirms women's right to freedom of opinion and freedom of expression. It states that this should include the right to hold and express the belief that men cannot become women. No one should be punished for this by the law or by private or public organisations. It should not be grounds for sacking someone that they say that sex is immutable and men can't change their sex. No one should be compelled to name others according to their gender identity rather than their sex. In combating violence against women, this is particularly important when women and girls are describing their experiences of physical and sexual assault. In the UK, women giving evidence in court have been compelled to call men who have assaulted them she. If this kind of compelled speech is allowed to continue, women and children giving evidence against men who've raped them could be compelled to call their rapist she, if those rapists claim a female gender identity. And they could be compelled, when talking about the physical acts that have taken place in the assault, to use female pronouns to describe what happened and talk about her penis. This type of compelled speech is an infringement of the right to freedom of expression in any context. In a criminal justice context, it undermines access to justice, and particularly for women and girls. The right to accurately describe the sex of those who've assaulted them is crucially important to the ability of women and girls to report violence and give evidence against their abusers. The Declaration states that the rights of women and girls to access justice should include the right to name the sex of those who've perpetrated violence against them, and that public bodies such as the police and the courts should not try to force women and girls to describe their attackers according to their claimed gender identity rather than their sex. Article 5 of the Declaration reaffirms women's right to freedom of peaceful assembly and association. Women's rights to freely associate, to assemble and to organise on the basis of our common experiences as a sex, without including men, was crucial to the development of the feminist movement and is still crucial to its continuation. Everything we know about violence against women and girls has come into the public domain because of the feminist movement. The CEDAW and the UN Declaration on the Elimination of Violence Against Women would never have come into existence if the feminist movement had not first enabled women to name their experiences of men's violence towards us. And our knowledge and understanding of that violence in all its many forms grew from the work of feminist organisations all over the world, which set up rape support services, movements to establish shelters for women and children escaping domestic abuse, and other services and organisations working to combat men's violence against women and girls and to support women and girls who've experienced that violence. These were women-only groups, and that was crucial to their ability to do what they did. Women-only groups enabled women to name their experiences without feeling constrained or silenced by the presence of men. In these groups, women began to realise that their experiences of child sexual abuse, sexual violence as adults, domestic abuse, and other violence perpetrated against women by men were not unique to them as individuals. When women realised that these experiences were shared by large numbers of women and girls, they began to understand that men's violence towards us is a tool of dominance and control. And that is recognised in the Convention for the Elimination of Violence Against Women, it's specifically stated. That came from a feminist understanding of violence against women and girls. Our freedom to organise in women-only groups to defend our rights as a sex is now threatened by demands that we include men who claim a female gender identity in our political organisations and our campaigns. All of the sex-based rights of women and girls flow from the principle that women are a sex and not a gender identity. The project to replace sex as a social and legal category with a category of gender identity, which is represented in its most extreme form by the Yogyakarta principles, undermines and potentially erodes all of the sex-based rights of women and girls. It undermines our ability to name the human rights abuses to which we are subjected on the basis of our sex, and to organise against these abuses independently of males. The principles which are reaffirmed in the Declaration on Women's Sex-Based Rights are crucial to our ability to defend our rights and to work towards genuine equality of the sexes. Thank you. The Yogyakarta principles have no formal status in law, but they've been very influential because of the way they've been promoted. So anyone in any context who can find ways to promote the Declaration and refer to it and talk about things like, is it compatible with the Declaration? Well, the Declaration says this or that, and that calls into question what you're doing here in terms of recognising gender identity and what about women's rights. I think in different ways we can all do that, whether it's in law or in other contexts. That's what other lobbyists have done and campaigners have done in a different direction, and we need to be pushing back and using the Declaration in every way that we can in whatever context we work in. And it works. So, well, did you know that there's the Declaration on Women's Sex-Based Rights, and this is what it says, so that the Declaration starts to filter through into people's minds. And in addition to that, I mean, I suppose the thing that occurs to me most is there's been a creep in regard to people's acceptance of gender identity ideology, and people are accepting it for all sorts of reasons. They think it's inclusive, they think that you know, it's a liberal thing to do, they're scared of challenging it, or whatever it might be. So I think it's important wherever we can to question it, you know, and we can assess in a particular situation how safe it will be to question. I'm not saying women should start speaking up at work and get sacked. You can assess how what you can and can't say, but every opportunity, try and say something, try and question it. This idea that it's gender identity and accepting it is about inclusivity and equality is really, really widespread. Because people have just adopted it without thinking about it critically. And I think that that's something we need to be challenging all of the time, and coming back with arguments about why it's actually really dangerous from the point of view of women's equality. And it's the opposite of the promotion of equality. It's actually the promotion of sex stereotypes, and effectively creates an environment where it's impossible for women to defend our rights. And I think in every opportunity that we have to say that, in whatever way we can, it's important to do that. And there's different situations in which different women can do that, and some have more of a platform to say things than others. But maybe we could all say something to friends, to relatives, maybe in the workplace, gradually, and see what, test the ground and see how far you can go. But if we all start doing that, then feminist ideas about this and ideas about sex-based rights will become more and more commonplace, and people start thinking about them a lot more.